If you are an employer planning to sponsor a foreign worker for an H-1B visa this year, or if you are a foreign professional hoping to be registered in the upcoming lottery, I need you to pay very close attention to the next few minutes, because there are changes to this year's H-1B registration process that are bigger and in some ways more consequential than anything we have seen in years. And I am not just talking about the $215 registration fee, although that is absolutely one of the things we are going to break down for you today. I am talking about a complete overhaul of how the H-1B lottery itself is structured, a shorter registration window than in prior years, a brand new presidential proclamation that could trigger an additional fee of $100,000 in certain cases, and a set of technical registration requirements where one small mistake can cost you your spot entirely. So if you are serious about the H-1B process this year, this is the video you need to watch from beginning to end. Let's get into it. Let's start with the basics for anyone watching who may be newer to this process. The H-1B visa program allows U.S. employers to temporarily hire foreign nationals to work in specialty occupations. That means jobs that require the theoretical and practical application of highly specialized knowledge, along with at least a bachelor's degree, or its equivalent in a directly related field. We are talking about engineers, software developers, physicians, accountants, architects, and many other highly skilled professionals. The H-1B program is cap subject, which means Congress has set a limit on how many of these visas can be issued each fiscal year. That cap is 65,000 visas under what is called the regular cap, with an additional 20,000 available for individuals who hold a master's degree or higher from a U.S. academic institution. That secondary pool is often called the master's cap or the advanced degree exemption. Together, that is a total of 85,000 H-1B visas available each year. And for years now, demand has far exceeded supply, which is why there is a lottery. Now let's talk about the registration window this year. According to USCIS's official announcement on January 30, 2026, the initial registration period for the fiscal year 2027 H-1B cap will open at noon Eastern Time on Wednesday, March 4, 2026, and will close at noon Eastern Time on Thursday, March 19, 2026. That is only 15 days. And I want to emphasize that, because in prior years, the window has been slightly longer. This year, it is shorter. That means there is less margin for error. If an employer has not already begun gathering the required information, organizing their candidate documentation, and confirming their USCIS online account details, they are running behind. I cannot stress this enough. Preparation before March 4 is not optional. It is essential. So let's talk about the fee, because the $215 per registration is generating a lot of questions and a fair amount of frustration, and both reactions are understandable. Under the previous system, the electronic registration fee was just $10 per beneficiary, $10. For fiscal year 2026, USCIS increased that fee to $215 per registration, and that same $215 fee applies this year for the fiscal year 2027 cap. According to USCIS's official fee schedule and the Federal Register guidance, this fee is non-refundable. That word, non-refundable, is the part that matters most. It means that if an employer registers 10 candidates and not a single one is selected in the lottery, the employer has spent $2,150 and received nothing in return. That is just the reality of the system as it now stands. For large companies sponsoring dozens of candidates, the math becomes significant very quickly. This is why preparation and selectivity in choosing who to register has never been more important. Here is the practical point embedded in that. You want to make absolutely sure that every candidate you register is genuinely qualified for H-1B classification before you pay that fee. Under the H-1B modernization rule, which went into effect on January 17, 2025, and which remains in force today, USCIS has clarified and in some areas tightened its definition of what qualifies as a specialty occupation. The rule also strengthened USCIS's ability to evaluate whether the degree held by the beneficiary is directly related to the duties of the position. So if you are an employer and you are registering someone whose degree field is only loosely connected to the job, you may win the lottery only to have the petition denied later, and you will not get your $215 back. This is why working with a qualified immigration attorney before registration, not after, is so important. Now let's turn to what is arguably the biggest structural change in the H-1B program in recent memory. On December 23, 2025, the Department of Homeland Security announced a final rule that fundamentally changes how USCIS selects registrations in the lottery. That rule went into effect on February 27, 2026, and it is being applied for the first time in this current registration season. The rule is called the weighted lottery, and here is how it works. Previously, and this is important to understand, the lottery was entirely random. Every registered beneficiary had one equal chance of being selected, regardless of what the job paid. That is no longer the case. Under the new weighted lottery, a beneficiary is entered into the selection pool more than once, depending on the wage level that the offered position falls under, according to Department of Labor guidelines. The Department of Labor classifies wage levels from Level 1 through Level 4. Level 1 represents entry-level positions where the worker is still developing skills. Level 4 represents the most senior, highly specialized, or supervisory roles. Under the new weighted selection rule, a registration for a Level 1 wage position gets one entry into the lottery pool. A Level 2 position gets 2 entries. A Level 3 position gets 3 entries. And a Level 4 position gets 4 entries. What this means in practice is that a highly paid senior-level candidate has 4 times the statistical chance of being selected compared to an entry-level candidate. USCIS and DHS have been transparent that the goal of this change is to prioritize higher-skilled, higher-paid workers in the H-1B program while still preserving pathways for employers who are hiring at all wage levels. Now, here is an important nuance about this rule that you need to understand if you are an employer thinking about how to position your registrations. USCIS has built in an anti-gaming provision. If the same beneficiary has registrations from multiple employers at different wage levels, USCIS will assign that beneficiary to the lowest wage level among all the registrations submitted on their behalf. This is specifically designed to prevent employers or attorneys from artificially inflating the wage level on paper to gain more lottery entries when the actual job duties do not support that wage level. USCIS will also be conducting closer consistency checks between what is declared at registration and what is submitted in the full petition later. In other words, the data you enter during registration is going to be scrutinized against the actual petition documents. Inconsistencies will be flagged. This is another reason to be precise and honest in every field of the registration form. Now, I want to bring up something that has been getting significant attention in the immigration community, particularly among employers who sponsor workers that come from outside the United States. On September 19, 2025, a presidential proclamation titled "Restriction on Entry of Certain Non-Immigrant Workers" was issued, and it introduced an additional fee of $100,000 that applies in very specific circumstances. This fee applies to new H-1B petitions filed on behalf of beneficiaries who are outside the United States at the time the petition is filed and who do not have a valid H-1B visa already. It does not apply if the beneficiary is already inside the United States and is filing for a change of status, an amendment, or an extension. But for companies that routinely hire H-1B workers from abroad who then need to go through U.S. consular processing, this $100,000 fee is a serious financial consideration that must be factored into hiring decisions. As reported by Mint's immigration attorneys and widely covered in immigration law circles, this proclamation has created a significant new cost layer for certain H-1B sponsorships. Please verify the applicability of this fee to your specific hiring situation with qualified counsel before making decisions. Let's talk about some practical scenarios so this all lands concretely. Imagine you are a mid-sized technology company based in Texas. You have 3 candidates you want to register. One is a software engineer being offered an entry-level role at a level Y wage. Another is a data scientist at a level 3 wage. The third is a principal engineer at a level fee wage. Under the new weighted lottery, your entry-level candidate gets 1 lottery entry. Your data scientist gets 3. Your principal engineer gets 4. You pay $640 in registration fees for all 3. The lottery runs. Your data scientist and your principal engineer are both selected. Your entry-level candidate is not. You have now paid $215 that will not be refunded for the unselected candidate, and you move forward with filing petitions for the 2 who were selected. That is the system in action. Now imagine a different scenario. You are a staffing company that historically has used the H-1B program to register large numbers of candidates at inflated wage levels on paper to maximize lottery entries. Under the new rule, USCIS will look at the consistency between your registration and your petition, and inconsistencies can result in denial or even fraud referrals. The days of gaming the lottery are over. The beneficiary-centric process introduced in fiscal year 2025, combined with this new wage-weighted rule, has dramatically reduced the abuse that plagued the lottery for years. According to USCIS data, in fiscal year 2025, there were significantly fewer instances of multiple registrations and fraudulent registrations than in prior years, largely thanks to these reforms. That is good news for legitimate employers and genuine candidates. So, what are the concrete steps you should take right now, whether you are an employer or a foreign national hoping to be registered? First, if you are an employer, confirm that your USCIS organizational account is active and accessible. If you used an account for fiscal years 2021 through 2024 but did not use it in fiscal year 2025, USCIS has noted it will be converted to an organizational account format upon your next login. Make sure you know your login credentials now, not on March 4th. Second, gather all required beneficiary information in advance. That means complete, accurate legal name as it appears on the passport, passport number, country of birth, country of citizenship, date of birth, and the specific job details including the wage level and the ONET occupation code for the position. Third, confirm your payment method and make sure funds are available. The daily credit card limit for online H-1B transactions has been set at $99,999.99 per credit card per day. If you are registering more candidates than that daily limit covers, consider setting up an automated clearinghouse or ACH payment with your bank in advance. Fourth, if you are a foreign national, work directly with your sponsoring employer and their immigration attorney to ensure your information is prepared and verified before the window opens. A single data entry error, a misspelled name, a transposed passport number, an incorrect date of birth, can result in your registration being flagged or rejected. This is not the place for guesswork. Fifth, both employers and candidates should be aware that USCIS has reinforced the attestation requirements at registration. Every registrant submits a declaration under penalty of perjury that the information is complete, true, and correct, that the registration reflects a legitimate job offer, and that the employer has not coordinated with other registrants to game the system. These are legal attestations. They carry real legal weight. Sixth, if selected, employers must file the full H-1B petition within the designated 90-day window after receiving the selection notice. USCIS has indicated it intends to notify selected registrants by March 31, 2026. One more critical point for F1 student visa holders who are hoping to use the H-1B lottery to transition from optional practical training to H-1B status. The cap gap provision, which was extended under the H-1B modernization rule, now protects your work authorization through April 1st of the following fiscal year, while your H-1B petition is being processed. So for candidates selected in the March 2026 lottery, your OPT and cap gap protection would extend through April 1st, 2027 if needed. This is an important protection that prevents gaps in your ability to legally work while the petition is pending. Make sure your employer's immigration attorney is tracking your OPT expiration date closely and filing well within the required timelines. Now, a broader note. The H-1B landscape in 2026 is one of the most dynamic it has been in years. Between the new weighted lottery, the anti-gaming measures, the tightened specialty occupation standards, the $100,000 fee for certain new beneficiaries, and the continuing scrutiny under USCIS's Fraud Detection and National Security Site Visit Program, the program is more rigorous and less forgiving of sloppy preparation than ever before. The FDNS, which is USCIS's compliance enforcement unit, conducts unannounced site visits to employers to verify that H-1B workers are actually performing the stated job duties at the stated location for the stated salary. If your records do not match your petitions, you could face serious consequences. This is why we always say that H-1B compliance does not end when the petition is approved. It is ongoing. I want to be very direct before I close. Immigration policy in the United States is evolving rapidly. What is in place today can change through executive action, regulatory rulemaking, or court decisions. We have seen that play out in real time over the past several months. As of February 20th, 2026, all of the information I have shared in this video reflects the current official guidance from USCIS, DHS, and the Federal Register. But I strongly encourage you to verify everything through official sources directly. Go to uscis.gov and check the H-1B cap season page and the electronic registration process page. Check the USCIS fee schedule, Form G1055, for confirmed registration fees. And for anything specific to your company's situation or your individual case, please consult a qualified licensed immigration attorney. Nothing in this video constitutes legal advice. It is informational, and it is here to help you ask the right questions and walk into this process prepared. If this video helped you understand the H-1B registration process for 2026, please give it a thumbs up. It makes a real difference in helping Immigration News Today reach more employers, HR professionals, and foreign nationals who need this information. If you have not subscribed yet, please do so right now and hit the notification bell so you never miss an update. We are covering every major development in this H-1B season in real time, from registration to petition deadlines to lottery results, and you do not want to miss any of it. Check the video description for links to the official USCIS H-1B cap season page, the Federal Register rule on weighted selection, and USCIS's official fee schedule. Share this video with your HR team, your immigration attorney, or any colleague who is navigating this process. And as always, we are here to help you move forward with clarity, confidence, and the right information in your hands. We will see you in the next one. Policy changes can occur. All information is current as of February 20th, 2026. Viewers are strongly encouraged to verify all details with official sources including USCIS, uscis.gov, and DHS, dhs.gov, and to consult a qualified immigration attorney for advice specific to their individual situation. This video is for informational purposes only and does not constitute legal advice.